Welcome to It's No Accident, a podcast about the challenges of personal injury and wrongful death law in Florida, one of the nation's most complex legal environments.
You'll hear compelling stories about real cases from our law firm in Tallahassee that will help you better understand your rights and protect yourself from the negligence of others.
I'm Mark Nani.
And I'm Jaeson Hamola.
And this is
It's No Accident. All right, one of the topics we want to talk about today that has come up is negligent security cases. Mm-hmm. These are cases that we've handled in this office before, and really it's an offshoot of just a typical negligence case, and they really became prevalent after gun violence became more of something that we were seeing on the news pretty much every week, every month. And it's become a situation where, you know, if someone gets hurt on somebody's property because of physical violence, sexual violence, gun violence, you know, the families that are affected, the people that are affected are looking for somebody to place that blame on. And a lot of times, you know, you're looking to the person that actually you know, the main actor, the main bad actor that caused the situation. But then beyond that, you know, the person that caused the rapist or the sexual assault perpetrator, the shooter, you know, you're looking at that. But beyond that, you start to look at what could have been done to prevent this person from coming on this property and creating this situation. So, Mark, do you want to talk a little bit about what we're looking at in terms of a negligent security case and the things that have to fall into place to have a viable case?
Sure, yeah, no, absolutely. Like you said, it's definitely, I feel like, become more and more prevalent over the years. And like you said, I mean, we see it with, I'd say, I guess for the cases we've handled here, mainly in like apartment complexes is where it comes up a lot, and then also just at different businesses, right? Like retail places. And, you know, the main thing is for these cases is it all comes down to, essentially foreseeability and notice, right? And when we're investigating one of these cases, you know, the main thing we're looking into is, was there any, prior to the incident, like prior to the shooting or prior to the rape or whatever bad thing that happened, prior to that, was there anything happening in the days or months or, you know, weeks or months leading up to it that should have put the apartment complex or the business on notice that there's dangerous activity going around here, and as a result they should have taken better measures to protect their customers, right? And that's, you know, the cases that are the viable cases that go forward, that's the main thing. There's usually pretty, you know, stark bad evidence, I would, so to speak, that there was a long history of, you know, criminals coming onto the property with guns and shooting each other or robbing people or breaking into apartment complex, you know, into apartments within the complex, you know, going back for weeks or months, and the business or the apartment complex or whoever is just doing nothing, just digging their head in the sand and not taking any measures to, you know, try to protect their customers, really. I mean, it's kind of almost like they're leading their customers into a trap. They know that there's violence or, you know, criminal activity going on here, and they don't warn them, they don't do anything to protect them, and then people come in and they get, you know, shot or, you know, beat up or whatever, right?
Yeah. And, you know, it's not necessarily always the specific property that the bad incident happened on. You know, what we're also looking for is, you know, was this a bad neighborhood? Right. And was it foreseeable that, you know, there's been 10 shootings that's happened in the 5 properties around me. I've been lucky enough not to have one happen on my property, but I've also not had any security guards, not had any other security measures that have been, you know, proper lighting, other security measures that have been put in place to guard against this thing. You know, you're still on notice that you're in a bad area. Just because it hasn't happened on your property, it's only a matter of time.
Right.
You know, if you've got, you know, 10 shootings in the 5 properties around you, it's going to happen to you. Right. And, you know, we're looking at that as well. And you can't just sit back as the owner of a property and say, well, you know, it hasn't happened here yet. It's almost like the first bite rule for a dog, you know. Right. I'm not on notice, where the business owner says, I'm not on notice that I need to do anything because that hasn't happened on my property. Well, actually, the law says, yes, you are, because the properties around you have been, you know, affected by these situations. You should have known, or you're on notice that it could happen on your property, and the law says you should have taken those steps to protect the patrons that are coming onto your property.
Exactly. And I mean, I know like when we get a potential negligent security case, I think one of the first things we do is basically run a search to figure out, okay, what kind of crime, get the address of where it happened. And then, through like Tallahassee Police Department or some of the law enforcement agencies, you can run a search and figure out within, 3 months or 6 months leading up to this incident, within a 1 mile radius of where it happened, what was the crime activity like, right? And that's usually like, I think one of the main starting points to get an idea of like, okay, was, like you're saying, was there enough criminal activity going on in this area that the property owner or the premises owner should have known and should have done something about it.
Right. And that I think if a business were to have an attorney, a plaintiff's attorney, come onto their property and consult them as to, do I need to do something here? I think the first thing we're going to tell them is that, with the degree of risk, the higher the degree of risk, the more that you should be doing.
Right.
So, think about it in context of a bar, and think about that old movie from the 80s that just got remade, Roadhouse. If you're running a bar like that and you've got stabbings and shootings and fights breaking out every single night, your security is going to be higher than a bar that is serving martinis in the downtown area where you've got lobbyists and lawyers and other people coming in, and they haven't there hasn't been a fight there in 15 years.
Exactly.
So what you're looking at as a business owner and what we're looking at in terms of a case is did the business do what it was supposed to do in terms of the risk that was presented by what they've seen in the past.
Absolutely. And it is a balance, kind of like you're saying too, in terms of obviously business owners or apartment complexes or whoever it is, I mean, they can't just, it's impossible for them to just 100% completely ensure everybody's safety in every situation.
Right, and they don't have a crystal ball.
Exactly,
right.
And so it's, in terms of some like the measures that we're talking about, we've already kind of mentioned some of them. Like if the business is in a high crime area, they should be doing stuff like make sure they have good lighting when it's dark, right?
Right.
Maybe hiring private security, either getting law enforcement to come by the area more often, and or hiring private security, right? And doing things along those lines. And I guess what I'm saying is there certainly are situations potentially where a business is doing all those things and something bad still happens. And in that situation, maybe you don't have a lawsuit because the business has done all those things. Normally I feel like the cases that we've seen, it's a history of ongoing criminal stuff happening and the business literally doing zero, right?
Right, and there are safeguards for business owners too, especially, I know in the context of convenience stores, there is actually a law on the books in Florida that says, if you do, there's a list of things that if a convenience store has done these specific things, and it's like, you have security cameras. It's interesting because you may have wondered why, when you go into a convenience store, why they have that height meter on the side of the door. If you have one of those height meters on the side of the door, that's one of the check marks that is within the law, that if you have that helps you in terms of creating a presumption. If you've done these things, it creates a presumption against negligent security. It creates a presumption that you have done what you're supposed to do to protect yourself. And I don't know exactly. I think there's 8 to 10 different things that are in that checklist, and if you do them as a convenience store and somebody gets hurt on your property, there's a shooting, if you've done those things to safeguard yourself, there's a presumption that you get that you weren't negligent in that situation. Right. So there are things that can be done.
For sure, yeah, and it gives some business owners, especially like that example, convenience stores, kind of a guidepost to go on, so they're not just having to make it up themselves, kind of thing.
Exactly.
And I know last year, or no, I guess 2 years ago at this point, when there was a bunch of the tort reform laws got passed in Florida in March of 2023, I guess. There was a little bit of change in how the negligent security works with the verdict form, right?
Yes. The law, so prior to 2023, when you took a negligent security case to trial, and when you go to trial, there's what's called a verdict form, and it'll have all of the people that fault can be placed on. Prior to 2023, the like say the shooter, the bad actor would actually not be placed on the verdict form unless the plaintiff wanted them on the verdict form and they still had an open case against them.
Right.
If the case against them had been resolved, that person would then not be on the verdict form. And in 2023, March 2023, the legislature changed that so the bad actor would then can be placed on the verdict form, and plaintiffs can't prevent that from happening.
Right. Which makes it difficult because of course the thought behind that, I would say, I mean, obviously I'm not in the legislature, but I think it's pretty obvious. The thought behind that is people on a jury are going to say, well, who's the more at fault here? The guy who did, or person who did the shooting, or the apartment complex, and hoping that as much fault gets placed on the shooter as possible, right? Because on the verdict form, the jury can put percentages, right? Like it's 50% the apartment complex's fault and 50% the shooter's fault, or 60-40 or whatever, right?
Right.
And the hope is they're going to put as much of the fault on the criminal as possible, because that's going to get blame off the business basically. And the reality for our clients in that situation is usually the shooter or the criminal or whatever doesn't have any money we win. We win the judgment against that person at trial, but the odds of ever getting a penny on that are it's not worth the paper it's written on, kind of thing.
They don't have any money, and there's not going to be any insurance available for them.
No.
So what we're looking for is the business that the argument is that you facilitated this. I mean, you created a situation where you made it so easy for them to come onto your property and do what they were going to do, that you should be held responsible as well.
No matter your injury, Nani Hamola is here to help you recover. Visit noho.law today.